Hello friends, this is Sanjay. In this series, I will be covering the CLAT PG 2024 previous question paper from the exam that was actually conducted in December 2023. I will discuss the answers and also try to explain the way in which this question paper could have been attempted. CLAT PG 2024 had 24 passages with 5 questions per passage. So 120 questions in total to be answered in 120 minutes. In this part, I will be covering the first passage and the 5 associated questions. At Lawment, we have been publishing the CLAT PG mock test series since 2018 and till 2019, the CLAT PG had the regular MCQs based on the standard LLB subjects. From 2020 onwards, the pattern was changed to the so-called comprehension-based MCQs that we see today. But like you will see for yourself, this is not a completely comprehension-based exam, because not all the answers are directly based on the passage. While discussing the questions, I will mark them as direct, external and contextual. The answers for the direct questions can be found within the given passage, or sometimes they can be inferred by evaluating the answer options themselves. External questions are not based on the passage. They can be answered through your external legal knowledge, usually based on your LLB subjects or general legal awareness. This is where solving the old pattern mock tests and previous question papers is very useful. Contextual questions can be answered through your knowledge of the source from where the passage has been taken. You will understand this better when we start answering the questions. Throughout this series, I will make it a point to repeatedly highlight the importance of the elimination strategy. Whenever you come across a question where you are not sure about the answer and you need to take a guess, then eliminate the obviously incorrect options first and the least probable options next. And with every answer option that you eliminate, the probability of selecting the correct answer increases. If you have to select 1 out of 4 options, your probability is 25%. If you eliminate at least one option, you need to select from among the 3 remaining options. So the probability increases to 33%. If you manage to eliminate 2 choices, then the probability goes up to 50%. You can pause the video here and read through the passage. Or if you are a Lawment subscriber, just log into the practice portal and you will find this question paper as a mock test in the test series. I strongly recommend that you should read the passage and the source so that you can better understand the approach that I am taking for answering these questions. This passage is drawn from a 2021 Supreme Court case that involved the Tata Group and the late Mr. Cyrus Mistry, who was the executive chairman of Tata Sons for a couple of years before being voted out by the board. Now remember, the CLAT PG 2024 was conducted in December 2023 and this case is from 2021. So very few students would have read this case, and even if they had read this case sometime in the past, it would be difficult to remember the intricate details because this was a 280-page judgment, which means that most of the toppers and the successful candidates used the elimination strategy effectively to answer these questions. The first question is asking us the parties to this case approached the Supreme Court under which of the following provisions. From the available details, you can easily identify that this is a corporate dispute and definitely not a class action suit. So eliminate option B. If you remember Article 136 of the Constitution, that is the discretionary power of the Supreme Court to grant leave to appeal against any judgment or order of any high court or tribunal. That is the special leave petition that is being referred to here. Now, the SLP is filed only in case of a substantial question of law or a gross injustice or a miscarriage of justice. For example, an SLP is filed not just to appeal that a decision or an order is wrong, but to say that the law that is the basis of the decision or the order, that itself is wrong. If you read through this passage, the Supreme Court is saying that the NCLAT order may not be good, since it is granting a relief that was not actually sought by the appellant. But nowhere in the passage is there any question raised about the actual laws affecting this case, such as the Companies Act. So this cannot be a SLP situation because the law is not being questioned here. So that eliminates option C. Now we are left with sections 421 and 423. Typically, when you look at the path of a case, there is the first order or the first judgment, which is then appealed in the High Court, or in this case, the Appellate Tribunal. And finally, there is the Supreme Court. And the sections in most laws follow the same flow. For example, in an imaginary act, if section 100 talks about the first level, then section 101 will talk about the next level, that is the appeal, and section 102 will talk about the highest level of appeal, that is the Supreme Court. So between 421 and 423, I would select the higher number because the highest number may correspond to the highest court, that is the Supreme Court. And in this question, option A, appeal under section 423 is the correct answer. Now, this logic may not work in all cases, such as if the answer options were sections 423 and 424, then selecting the highest number would be incorrect. But given that I had to choose between the two remaining options and I did not have any further information to work with, I would have used this logic and my probability of choosing the correct answer would still be 50%. Since we arrived at the final two choices using the information within the question and some info from within the passage, this is mostly a direct question. This is also an external question that could be answered if you are thoroughly familiar with the Companies Act and the important articles of the Constitution. Since I would have found it difficult to remember the details of a 280-page case from 2021, especially since this case was not in the news in 2023, I don't consider this to be a contextual question. In India, which case diluted the majority rule and held that the interest of the company was above the interest of its shareholders, either majority or minority. If you search on Google with the name of the case and PDF, you can download this judgment from the Supreme Court website. As I have mentioned earlier, this is a fairly long 280-page document, and if you read through it, you will see that all of these four cases have been mentioned in the document in paragraphs 16.21, 16.52, 16.53 and 20.15. For this question, I want you to test yourself and see if you can identify the answer by reading through these four paragraphs in the judgment text. When you read through the judgment, you will see that the answer is not directly available there. That is, the judgment does not have the same words as given in the question. You will have to analyze the judgment text a little and you should be able to answer this question. So this is somewhat of a contextual question. However, I would consider this to be more of an external question because if your LLB corporate law syllabus included these landmark cases, then you should be able to answer this question faster. The correct answer here is option D, that is the case about Needle Industries. Coming to the third question, this question itself is partially incorrect. It should have been challenged, maybe it was, but the question has not been cancelled. Why is it incorrect? Well, first of all, there is no Kotak Mahindra committee. It was a committee formed by SEBI to study and give recommendations on a set of corporate governance related issues. It is also referred to as the Kotak Committee because the chairman of this committee was Mr. Uday Kotak. At that time, Mr. Kotak was also the EVC and the MD of Kotak Mahindra Bank. But Kotak Mahindra Bank did not have anything to do with this committee or its report. So Kotak Mahindra Committee is incorrect. It should just say Kotak Committee. If we ignore that error and go through this complete case judgment, there are several references to the Cohen Committee report. But that is not the correct answer to this question. The correct answer is Cadbury Committee report. This is a completely external question, and the only connection between the passage and this question is that both are about corporate governance. Other than that, the Kotak Committee report, the Cadbury Committee report, Hampel Committee report or the Narayan Murthy Committee report, none of these are mentioned in the passage or even in the complete judgment. The Cohen Committee report is mentioned, but that is not the correct answer here. This question could be answered if a student has read the Kotak Committee report in detail, which is a little unreasonable because the Kotak Committee report came out in 2017. This question could also be answered if a student has read the Cadbury report and remembers this statement, which is also unreasonable because the Cadbury Committee was set up by the London Stock Exchange in 1991 and this report came out in 1992. Or another possibility is that these reports have been covered during your LLB corporate law classes, which is again a little far-fetched unless your university syllabus has an in-depth corporate law core or optional subject. So in short, this is a completely random question, so don't worry if you are not able to answer this question correctly. Question number 4 is asking about the requirements under Section 244 for applying for relief under Section 241 of the Companies Act. This is not a direct question because this answer is not directly available within the passage. This is a contextual question because the actual judgment text contains the answer. This is also an external question because it can be answered if a student is familiar with the requirements of the various provisions of the Companies Act. In question number 5, there are two statements and we have to identify whether these statements are true or untrue. This is a contextual question because the answer is available in the source of the passage. This is also an external question because it can be answered if you are familiar with the Companies Act. This is also a partly direct question because we can use some of the information from within the passage and also make some general assumptions to choose the correct answer. The trick with questions like this is to use the elimination strategy to make sure that you don't get confused. And obviously, the elimination strategy will also make it easier if you have to guess the correct answer. When we read both of these statements, we can see that statement 2 is obviously incorrect. It says that section 242 does not empower the NCLAT to grant relief by preventing apprehended mismanagement. Here, we already know from the passage that both the NCLT and the NCLAT have the powers to grant such a relief. Otherwise, why would they be approached by the parties in this case? Now, the only point of doubt may be whether section 242 of the 2013 Act deals with this topic or not. But we can safely assume that it does, which means that statement 2 is untrue. Since statement 2 is untrue, it means that option D, which implies that statement 2 is true, can be eliminated. And also option A, which implies that only statement 1 is untrue, can also be eliminated. By eliminating options A and D, we have already reached a 50% probability level. Statement 1 says that the powers that were originally vested with the High Court under section 402 of the Companies Act of 1956 have been transferred to the NCLT by section 242 of the Companies Act of 2013. This is incorrect because when the original 1956 Act was passed, section 402 empowered the courts, which meant the district court or the High Court which had the jurisdiction. After 1991, when the Company Law Board was formed, then court was replaced with the Company Law Board. And after 2002, the CLB was replaced with the Tribunal. So the Companies Act of 1956 already empowered the Tribunal, and this was not done by the Companies Act of 2013. Since both 1 and 2 are incorrect or untrue, the correct answer here is option C. In the next part, I will cover passage 2 and the next 5 questions. I would recommend that you should read the passage, the source, and also attempt the 5 questions on your own before you watch the video so that you can more easily follow our discussion. You can also go to lawman.com and check out our CLAT PG practice series for the upcoming exam, which includes all the CLAT PG previous papers and both new and old pattern mock tests for CLAT PG and other LLM entrance preparation. You can also attempt a free full-length mock test to get a feel of the series. I will see you soon in the next video. Jai Hind.